All rise.
All right.
RCC Foundation.
Hey, good afternoon to everyone. I apologize for the brief delay, but we had a rules meeting for the district court dealing specifically with EDCRs, and so I had to make sure I was there so we had a quorum.
Just sort of need more rules.
We agree. And I've cut away a few rules. Anyway, once again, good afternoon. Let's go ahead and set forth our appearances for the record.
Hi, Will Kemp for Plaintiff.
Good afternoon, Odou on behalf of Lifestyles Inc.com, Real Water Inc., and Real Water Gold Coast.
And on the telephone, on the feed, who do we have?
Good afternoon, Your Honor. Brennick Werflin on behalf of Milwaukee Instruments and Hanna Instruments.
Good afternoon, Your Honor. David Spurlock on behalf of United Natural Foods and the Whole Foods.
You can be seated. There's a few more. I don't want to overlook anyone.
Good afternoon, Your Honor. I'm sorry, this is Teddy Parker. Good afternoon, Your Honor, on behalf of Plaintiff Keith Haley.
All right.
Afternoon, Your Honor. Jim Cavanaugh, Gordon Reese in Las Vegas, on behalf of third-party defendant, Real Water of Tennessee, LLC.
Good afternoon, Your Honor. Eric Pepperman for Plaintiffs.
Good afternoon, Your Honor. This is Michelle Anastasio for Milwaukee Instruments defendant.
And does that cover all the appearances? One more?
Your Honor, Laureen Frister for Cahee Distributors. We're a non-party in the Gallagher case, so just observing for today. Thank you.
All right. And I think that covers all appearances. Is that correct, ma'am?
Mr. Neal checked in. I didn't hear him say anything.
Mr. Neal. Was appearances noted.
Okay.
Let's move on. Anyway, once again, good afternoon, and it's my understanding we have a couple of motions for good faith. Is that correct?
Yes, Your Honor.
And we have AffinityLifestyles.com's motion for determination of good faith settlement with plaintiffs on behalf of Keith Haley. Is that one?
Yes, Your Honor.
And the second would be settlement with plaintiffs Orion Gallagher, Brian Gallagher, and Camille Gallagher. Is that correct, sir?
Yes, Your Honor, it is.
All right, so you have the floor, sir.
Thank you, Your Honor. I'll take both motions together. Both sets of plaintiffs, the Gallagher family and Plaintiff Haley, issued offers of judgment to the Real Water defendants, and Real Water accepted those offers of judgment. Both settlements are the same amount. The factors set forth in the MGM Grand Fire litigation provide the relevant consideration for this court. Certainly, it's no secret that the Real Water defendants declared bankruptcy. That bankruptcy was set aside in order to allow the plaintiffs in this case and approximately 22 other cases to pursue insurance for the purposes of liquidating their claim. This case is part of a consolidated or a coordinated group of cases. I believe 18 or 19 of those cases are now coordinated. The amount paid in settlement in both was the exact offer of judgment issued by the plaintiff. Therefore, there's no evidence of collusion. I might even add, Your Honor, the motions are not really opposed. UNFW filed a response to the motion to clarify that the scope of the good faith finding would be limited to those factors set forth in Nevada Revised Statute 17245. And they wanted to make sure that there was no finding that any contractual claims were dismissed, and that is certainly not the subject of the motion. It was not requested. The second factor under the MGM group of factors, the allocation among the settlement among the plaintiffs, that's not applicable here. Certainly the settlement party has no say in how the settlement proceeds are allocated among the plaintiffs. The third factor is the insurance policy limits of the settling defendants. Those insurance policies have been produced in discovery. Some additional policies were recently discovered. Those are being produced for Real Water Gold Coast, but all insurance has been produced in discovery, or if there is a policy that hasn't been produced, it's being produced shortly. And the final factor is the financial condition of the settling defendants. And again, Real Water is bankrupt, and these claims are to liquidate the claims for the purposes of going after the insurance policies. And so because of the lack of opposition to the motion, we request the court find it in good faith in NRS 17245 and dismiss any claims for equitable contribution or equitable indemnity. And we're not seeking the dismissal of any contractual claims, if any exist. There was a response also filed by the plaintiffs as to the allocation of the settlement, and I'll let plaintiffs talk about that. I'm sorry, whether there was a finding of offset by this court, and that is really beyond what I have asked for on behalf of the Real Water defendants, so I'll let plaintiffs speak to that, and be happy to answer any questions the court has.
All right. Okay, thank you, sir. Mr. Kemp.
First of all, Your Honor, it's kind of mind-boggling to see the MGM case where I filed the good faith motion over 40 years ago cited as an authority. You know, it's makes you feel old.
It shows we matured.
Yes, the case has matured well.
Yes,
right?
it has.
All right. I think the only issue we have is UNFW asked to make a determination of the offset at this time. We just think that's premature, and I think we've been pretty candid in our pleadings that we think most likely they're going to get the offset. Okay, but you do have to wait and see the judgment rendered against them. And then you would apply the J.E. Johns case. That's our new offset case. So I think they're going to get the offset, but I think it's just premature at this time, and it's really not part of a good faith motion. It's really asking the court for kind of a preliminary opinion. But having said that, we have no other comments.
Okay, thank you, sir. All right.
Your Honor.
Yes, sir.
Your Honor, it's Jim Neal for UNFW. I hope you can hear me now. I think I've straightened out my microphone.
And very clearly, sir.
Very good. Thank you. It sounds like the parties are largely in agreement. I think there are perhaps only two outstanding issues, and those are these. Number one, to address the point that Mr. Kemp just made on the allocation of the offset. This is a case, Your Honor, where whatever offer of judgment that is accepted will be paid from insurance proceeds. This is a case where the plaintiffs stipulated to lift the bankruptcy stay and proceed only against insurance policies. This is a case, Your Honor, where the insurance company has filed a declaratory judgment action in the bankruptcy court saying it's not liable for punitive damages. So I agree with Mr. Kemp that the non-settling defendants will eventually be entitled to the $250,000 offset under 17.245. But I don't think it's premature to include that in the order because there's no other possibility. The damages that are paid by Real Water are paid by the insurance companies. They have to be compensatory in this case. It's a single indivisible injury in which the other defendants are, in my client's case, alleged to be strictly liable for the distribution of a defective product. It doesn't get any more indivisible than that. Therefore, I think the offset applies. The only other issue I would, and I don't know that it's not a significant one in Mr. Haley's case. Gold Coast is not a party to Mr. Haley's case. Mr. Haley hasn't sued Gold Coast, and UNFW has not third-party Gold Coast as to Mr. Gallagher. Gold Coast, as I think the evidence demonstrates, distributed only the 5-gallon product. Mr. Haley is not a 5-gallon subscriber. Therefore, I assume that that entity is not participating in the settlement, doesn't have the claims released against it, and doesn't enjoy the extinguishing of any equitable indemnity or contribution under 17.245(1)A. Those are my points, Your Honor, unless the court has questions.
Not at this time, sir. And any other parties want to comment? I guess that's no one, right? Okay, we'll circle back. Mr. Odou, sir.
Just very briefly on Gold Coast, Mr. Neal is correct. Gold Coast is not arguably not it's a defendant in the Gallagher case. Whether or not the third-party complaint differentiates between the Gallaghers, Mr. Haley, the Ryerson plaintiffs, any of the other plaintiffs, it really doesn't. And so it's more of a factual issue. But I would note that Real Water Gold Coast was 70% owned by the bankrupt entity, Real Water Inc., and the other 30% was owned by Amy Jones, who has also declared bankruptcy. And so it's kind of a circular argument in that it comes back to insurance.
I understand. Mr. Kemp, sir.
I just think the credit issue is premature because they haven't been cast in judgment yet until United.
Well, I agree with that. I mean, I thought about it. I mean, at the very least, if there was like a stipulation of liability, maybe I'd consider it, right? But we're not there yet. And then, I mean, and this has nothing to do with the competency of counsel, but there's no guarantee there's recovery. I mean, there just isn't, right? I mean, so that's something I have to factor in to whether it's premature or not. I mean, based upon the current case law, I would see no reason necessarily that hypothetically there's a recovery in excess of the 250, that there would be an offset, right? I get it. I mean, the law is so clear on that. But are we at that point in time right now, right? And so anyway, this is what I'm going to do. Regarding, I guess, both motions for the determination of good faith settlement, as far as those are concerned, Mr. Odou, I'm going to grant those, sir.
Thank you.
Right? I'm going to reserve the offset issue until the appropriate time. But I will say this, I'm going to follow the case law. I mean, it's pretty clear. And so it's an issue with really no issue, probably, in all likelihood. So anyway, Mr. Odou, you can prepare the order. And where do we go from here? Do we have more offers of judgment I can look forward to being accepted?
No, Your Honor. Just so the court's fully informed, there have been offers of judgment flying back and forth.
Oh, I bet.
Between everybody else, but none of the others were accepted. So
I understand. I did.
So
I get
we don't
it.
anticipate making
It is. It is what it is. And if we have to go to trial, we'll go to trial. And so anyway, I guess I'm going to see you coming back on what, the 22nd? Is that correct, Ron?
Yes.
All right. And that's regarding the jury questionnaire?
Right, next Thursday, Your Honor.
Okay.
Thank you.
Everyone enjoy your day and keep those offers of judgment flowing.
Thank you.
Thank you, Your Honor.
You're welcome, sir.
Thank you.